1995 to 2002, as well as represent his country at various international legal conferences. He was a member of the International Law Commission from 1987 to 2006 and was elected as a chairman in 1995. He also acted as arbitrator in the Bay of Bengal maritime boundary arbitration between India and Bangladesh between 2010 and 2014. That same decade, he served as first vice president and president of the Institut du Droit International. He was also invited to lecture on law as visiting professor at various prestigious universities. These are just some of his many professional achievements in a life dedicated to upholding the value of international law as a practitioner, an advocate, a judge, and an academic. As a judge ad hoc at this court, Judge Srinivasa Rao is remembered with much fondness by his former colleagues who admired his ability to combine sharp, independent thought with a marked sense of collegiality. Judge Srinivasa Rao was a leading international jurist and a man of great integrity. He will be missed. On behalf of the members of the court and myself, may I offer our sincere condolences to the family of Judge ad hoc Srinivasa Rao. I invite you now to stand and observe a minute of silence in his memory. Thank you very much. Please be seated. I shall now turn to the judicial proceeding before the court today. The court meets this morning under Article 74, Paragraph 3 of the Rules of Court to hear the single round of oral arguments of the Republic of the Sudan on its request for the indication of provisional measures submitted in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide in Sudan, Sudan versus United Arab Emirates. The court included upon the bench no judge of the nationality of either party. Accordingly, both parties availed themselves of the right under Article 31, Paragraph 3 of the statute to choose a judge ad hoc to sit in the case. Sudan chose Mr. Bruno Simma and the United Arab Emirates, Mr. Philippe Couvreur. Article 20 of the statute provides that every member of the court shall, before taking up his duties, make a solemn declaration in open court that he will exercise his powers impartially and conscientiously. Pursuant to Article 31, Paragraph 6 of the statute, the same provision applies to judge ad hoc, who have to make a solemn declaration in each case where they participate, as stated in Article 8, Paragraph 3 of the Rules of Court. In accordance with the court's practice, I shall first say a few words about the career and qualifications of Judge Simma and Judge Couvreur, before inviting each of them to make their solemn declarations. Judge Bruno Simma, of German nationality, served as a member of the court from 2003 to 2012 and was appointed as judge ad hoc in the joint cases concerning maritime delimitation in the Caribbean Sea and the Pacific Ocean, Costa Rica versus Nicaragua, and land boundary in the northern part of Isla Potias, Costa Rica versus Nicaragua, and in the case concerning the dispute over the status and use of the waters of Silala, Chile versus Bolivia. Judge Simma studied law at the University of Innsbruck, where he obtained a doctorate degree in 1966. In 1973, he became professor of international law and European community law at the University of Munich, where he went on to serve as dean of the faculty of law between 1995 and 1997. Judge Simma also has a long-standing academic career at the University of Michigan Law School, where he began teaching in 1986, was appointed professor of law in 1987, and where a chair was created in his name in 2009. He has twice been the director of studies of the Hague Academy of International Law, and in 2009, he delivered the prestigious general course in public international law. His publications in international law are numerous and well-known. Judge Simma was a member of the International Law Commission from 1996 to 2003. He has appeared as an advocate in various cases before the court and has sat as arbitrator in numerous arbitral tribunals. Since 1st December 2012, he has been an arbitrator at the Iran-United States Claims Tribunal. Judge Simma is the recipient of numerous awards, including honorary doctorate degrees. Judge Couvreur, of Belgian nationality, served as the registrar of the court from 2000 to 2019, having previously held various positions in the court registry since 1982, including that of principal legal secretary. Judge Couvreur studied law and philosophy at the University of Namur and the Catholic University of Louvain, before completing his postgraduate studies in international and European law at King's College London and Complutense University of Madrid. In parallel with his illustrious career at the court, Judge Couvreur has taught law as a visiting professor and guest lecturer at various universities. Judge Couvreur has also given courses at both the Hague Academy of International Law and the Sherman Academy of International Law. Since stepping down from his function as registrar, Mr. Couvreur was appointed as judge ad hoc in the case concerning Guatemala's territorial, insular, and maritime claim, Guatemala-Belize, and in the case concerning the arbitral award of 3 October 1899, Guyana versus Venezuela, both currently pending before the court. He is also a judge ad hoc at the International Tribunal for the Law of the Sea and serves as an arbitrator in investor-state proceedings. Judge Couvreur is an associate member of the Institut du Droit International, as well as a member of numerous learned societies. Throughout his outstanding career, he has authored many articles, monographs, and papers in French, English, and Spanish on a wide range of topics of international law and with a particular focus on the court. In accordance with the order of precedence fixed by Article 7, Paragraph 3 of the Rules of Court, I shall first invite Judge Simma to make the solemn declaration prescribed by the statute, and I would request all those present to rise. Judge Simma, you have the floor.
Thank you, Mr. President. I solemnly declare that I will perform my duties and exercise my powers as a judge honorably, faithfully, impartially, and conscientiously.
I thank you, Judge Simma. I now invite Judge Couvreur to make the solemn declaration prescribed by the statute. Judge Couvreur, you have the floor.
Merci, Monsieur le Président.
Thank you, Mr. President. I solemnly declare that I will perform my duties and exercise my powers as judge honorably, faithfully, impartially, and conscientiously.
Couvreur, please be seated. I take note of the solemn declaration made by Judge Ad hoc Simma and Judge Ad hoc Couvreur and declare them duly installed as a Judge Ad hoc in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide in Sudan, Sudan versus United Arab Emirates. I shall now recall the principal steps of the procedure in the present case. On 5 March 2025, the government of Sudan filed in the registry of the court an application instituting proceedings against the United Arab Emirates with regard to a dispute concerning alleged violation by the latter of its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide in Sudan, most notably in West Darfur. I shall refer to this convention as the Genocide Convention. To found the jurisdiction of the court, applicant invokes Article 36, Paragraph 1 of the Statute of the Court and Article 9 of the Genocide Convention. Together with this application, Sudan submitted a request for the indication of provisional measures pursuant to Article 41 of the Statute of the Court and Articles 73, 74, and 75 of the Rules of Court. The Registrar will now read out the passage from the request, specifying the provisional measures which the government of Sudan is asking the court to indicate, pending a final judgment in the case. You have the floor, Mr. Registrar.
Thank you, Mr. President. I quote, 1. The United Arab Emirates shall, in accordance with its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, in relation to the Masalit in the Republic of the Sudan, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of this Convention, in particular, A. Killing members of the group, B. Causing serious bodily or mental harm to members of the group, C. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and D. Imposing measures intended to prevent birth within the group. 2. The United Arab Emirates shall, in relation to the members of the Masalit group, ensure that any irregular armed units which may be directed or supported by it and any organizations and persons which may be subject to its control, direction or influence do not commit any acts described in point 1 above, or of conspiracy to commit genocide, of direct and public incitement to commit genocide, of attempts to commit genocide, or of complicity in genocide. End of quote.
I thank the Registrar. Immediately after the application and the request for the indication of provisional measures were filed, the Registrar transmitted an original copy thereof to the government of the United Arab Emirates. He also notified the Secretary General of the United Nations. According to Article 74, Paragraph 1 of the Rules of Court, a request for the indication of provisional measures shall have priority over all other cases. Paragraph 2 of the same article states that the court shall proceed to a decision on the request as a matter of urgency. This imperative must be, however, balanced with the need to fix the date of the oral proceedings in such a way as to afford the parties an opportunity of being represented at the hearings. The court decided that these oral proceedings would be held today on 10 April 2025. By letter dated 3 April 2025, the agent of Sudan informed the court that his government wanted to amend the measures requested in paragraph 22 of its request for the indication of provisional measures, dated 5 March 2025. The registrar will now read out the amended measures. You have the floor, Mr. Registrar.
Thank you, Mr. President. I quote, 1. The United Arab Emirates shall, in accordance with its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, in relation to the Masalid group in the Republic of the Sudan, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of this Convention, in particular, A, killing members of the group, B, causing serious bodily or mental harm to the members of the group, C, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and D, imposing measures intended to prevent births within the group. 2. The United Arab Emirates shall, in accordance with its obligations under the Genocide Convention, in relation to the members of the Masalid group, refrain from any conduct amounting to complicity in the commission of any of the acts described in point 1 above, by any irregular armed units or by any organization or persons. 3. The United Arab Emirates shall submit a report to the court on all measures taken to give effect to this order within 1 month as from the date of this order, and thereafter every 6 months until a final decision on the case is rendered by the court. End of quote.
I would now like to welcome the delegation of the parties. I note the presence of the agents and counsel of Sudan and the United Arab Emirates. This morning, the court will hear the single round of oral argument of Sudan, which has submitted the request for the indication of provisional measures. It will hear the single round of oral arguments of the United Arab Emirates this afternoon at 4 o'clock. Both parties have a maximum allotted time of 2 hours each for their respective oral presentations. At today's sitting, Sudan may, if required, avail itself of a short extension beyond 12 noon, in view of the time taken up by these introductory remarks. Before giving the floor to the agent of Sudan, I wish to draw the attention of the parties to Practice Direction 11, which states as follows, I quote, in the oral pleadings on request for the indication of provisional measures, parties should limit themselves to what is relevant to the criteria for the indication of provisional measures as stipulated in the statute, rules, and jurisprudence of the court. They should not enter into the merits of the case beyond what is strictly necessary for that purpose. End of quote. I now give the floor to the agent of Sudan, His Excellency Dr. Maiwa Osman Muhammad Khail. You have the floor, sir.
Mr. President, Madam Vice President, members of the court, it is an honor to appear before you as the agent of the Republic of Sudan. A genocide is being committed against the ethnic group, the Masalid, in the west of our country. The Masalid are non-Arab African ethnic group. The genocide against the Masalid is being carried out by the Rapid Support Force, paramilitary Arab from Darfur, with the support and complicity of the United Arab Emirates. It was recognized during the drafting of Genocide Convention that the Commission of Genocide will, quote, nearly always involve the complicity of state, end quote. That is so in the large-scale extermination of the Masalid in the precedent case. The ongoing genocide would not have been possible without the complicity of the UAE, including through the continued sponsorship and shipment of arms of RSF. The UAE continued to supply the RSF with increasingly heavy arms through cargo flight to Mjaras airport in neighboring Chad. Last year, 10,000 to 15,000 persons were killed in the RSF massacre of Masalid, the population of Al Jenaina in West Darfur. With increased firepower and support from UAE, the RSF has now leased siege to Al-Fashir in North Darfur. Al-Fashir contained large camps from 10,000 of entirely displaced persons from the Masalid tribe. The genocide violence that will ensue if Al-Fashir now falls and the RSF take it does not bear thinking. There is an immediate risk of repeat of extermination of Masalid at Al Jenaina. The direct logistic and other support that the UAE has provided and continue to provide it to the RSF and their affiliated militia has been continue to be the primary driving force behind genocide now taking place, including through killing, rape, forced displacement, looting, and the destruction of public and private properties. Professor Buer will set out the fact. Mr. Warsu Kisi will address the court prima facie jurisdiction. Mr. Ogi will deal with plausibility. Then Professor Bilachi will deal with the risk of irreparable prejudice and the professional measure requested by the Sudan. Mr. President, I thank you and ask that you now invite Professor Buer to the podium.
I thank the agent of Sudan for his statement. I now invite Professor Eirik Bjørge to address the court. You have the floor.
Mr. President, members of the court, it is an honor to appear before you on behalf of the Sudan to address the facts. As I will explain, including by reference to UN sources, there can be no doubt that the Masalit people is currently being subjected to genocide, and that there is serious evidence that the UAE is failing to prevent this and is complicit. I will also deal very briefly with the existence of the dispute in case the UAE seeks to raise this as a point. It is notorious that since November 2023, the Masalit non-Arab ethnic group in the Sudan has been targeted and subjected to acts of genocide and other prohibited acts, which continue to this day. The perpetrators of these acts are members of the Rapid Support Forces, the RSF, a militia comprised of Arab Darfuris, led by a former commander of the Janjaweed militia, General Mohammed Hamdan Daglo. The situation was accurately summarized as follows by the current US Secretary of State, the Honorable Marco Rubio, during his confirmation hearing before the US Congress in January of this year. By its very definition, this is a real genocide. This is the ethnic targeting of specific groups for extermination for elimination by groups, by the way, that are being funded by nations that we have alliances and partnerships with in other parts of the world, and we should express that clearly. I think, and part of our engagement with the UAE, and it will have to be a pragmatic engagement, I mean, they are important players in what we hope to resolve in the Middle East, and I think, as part of that engagement, we also need to raise the fact that they are openly supporting an entity that is carrying out a genocide. Against this backdrop, and in circumstances where the UAE's open support for the RSF continues, notwithstanding the fact that the RSF's ongoing siege of El Fasher is increasingly at serious risk of culminating in further acts of genocide, and the RSF's attacks against other gathering places in West and North Darfur for members of the Masalit people who have been displaced by the conflict have also escalated over the past month, the Sudan had no choice but to approach the court for urgent interim relief. It's important to understand why the current US Secretary of State felt able to express the situation in the forthright terms he used. In the spring of 2023, the RSF was increasingly capturing territory in Darfur. During clashes in El Janina in West Darfur in May-June 2023, the RSF and militias aligned with it carried out large-scale attacks on civilians, the Masalit population in particular. They conducted a systematic campaign to extirpate the city's Masalit community. The massacre by the RSF has been described as a deluge of atrocities and a killing frenzy. Between 10,000 and 15,000 persons were killed. In this and other atrocities, the RSF has targeted gathering sites for internally displaced persons, IDPs, which have been systematically attacked, burned, and destroyed. In November 2023, the United Nations Special Advisor on the Prevention of Genocide, Alice Wairumu-Deritu, described the events in West Darfur, in the following terms: rape and other forms of sexual and gender-based violence, including sexual slavery, have been rampantly perpetrated as a weapon of war. Entire villages have been burnt, often with the plan to attack announced in advance. Derogatory and dehumanizing language, such as slaves, has been persistently used as an element of incitement to violence. Conditions of life have been deprived, with medical facilities and transportation destroyed, and access to water and electricity deliberately obstructed. This all points to risk factors for genocide. Instrumental to the RSF's prosecution of its campaign of genocide since June 2023 was its securing of new supply routes for weapons, equipment, and logistics for use in the conflict. As a result, the RSF was now able to use several types of heavy and sophisticated weapons, and these played a major role in its capture of El Janina. In January 2024, the UN Security Council's panel of experts on the Sudan, whose members had been appointed by a composition of the Security Council, which included the UAE itself, reported that the RSF's main supply route for arms is through eastern Chad, which borders West Darfur. The panel assessed allegations that a heavy rotation of cargo planes coming from Abu Dhabi International Airport to Amjaras Airport in eastern Chad, transporting weapons, ammunition, and medical equipment for the RSF, as well as the UAE's denial and assertions that its cargo planes had a purely humanitarian purpose. The panel concluded that the allegations against the UAE were credible. According to information gathered by the panel from sources in Chad and Darfur, the allegations were credible. Several sources in eastern Chad and Darfur, including among local native and administrative leaders and armed groups operating in those areas, reported to the panel that several times per week, weapons and ammunition shipments were unloaded from cargo planes arriving at Amjaras Airport, then loaded on trucks. Continuing to seek to operate under the cloak of humanitarianism, the UAE in September 2024 built a field hospital, emblazoned with the banner of the Red Crescent, next to the Amjaras airfield. But, tellingly, when the Red Cross sought to visit in order to understand what the UAE operation was doing under its protected banner, the officials were turned away for security reasons. The assessment of the Sudan's General Intelligence Service was that the unnatural expansion of activity in the Amjaras airport facilities, the flights to the airport, and the heavy presence of combat vehicles and military camps are not consistent with the argument that this was for the purpose of providing the needs of the field hospital. An advisor to the American NGO, the Sudan Conflict Observatory, Justin Lynch, put it this way: there is no plausible explanation for these airlifts except for weapons support to the RSF. No one is fooled. Likewise, the Sudanese General Intelligence Service has concluded that the UAE's field hospital at Amjaras Airport is the primary supply and support hub for the enemy. It has also determined that the UAE is continuing to use N'Djamena Airport in western Chad for the same purpose. The UAE, for its part, has sought to characterize such conclusions as nothing more than a duplicitous media disinformation campaign. Meanwhile, on 22nd January 2024, the European Union designated Al Junaid Multi-Activities Company under its Sudan sanctions regime. This Sudanese holding company, which had already been designated under the United Kingdom's sanction regime, is owned by Abdul Rahim Daglo, the brother of General Hamdan and his two sons. The reasons given by the European Union for the designation included a finding that the RSF is also using Al Junaid's gold production and exports to secure military support from the United Arab Emirates, UAE, to which most of Sudan's gold production is smuggled, including the provision of weapons used by the RSF in the conflict in Sudan. On 21 May 2024, the United Nations Special Advisor on the Prevention of Genocide briefed the Security Council in a meeting where the UAE was invited to participate. She took the occasion at this meeting to raise the alarm, clearly and unequivocally, about the ongoing situation in the Sudan, which bears all the marks of a risk of genocide, including strong allegations that the crime has already been committed. Civilians are far from being protected, and civilian populations are being targeted based on their identity. In Darfur and El Fasher, civilians are being attacked and killed because of the color of their skin, their ethnicity, and who they are. The Special Advisor expressed extreme concern about the attacks on the ethnic Masalit community in West Darfur, allegedly perpetrated with an explicit intent to destroy, and emphasized that the human rights and humanitarian catastrophe unfolding in the Sudan contravenes the very essence of the international obligations to prevent and punish the crime of crimes, as enshrined by the Genocide Convention. The risk of genocide exists in the Sudan. It is real, and it is growing every single day. On 5 June 2024, the Special Advisor observed in connection with El Fasher that it was unquestionable that risk factors and indicators for genocide and related crimes are present, and the risks are increasing. And on 20 September 2024, she expressed grave concern over reports that the RSF had breached the third defensive line around El Fasher, with one of El Fasher's IDP camps, Abu Shuk, teetering on the edge of disaster. Further clear evidence of the UAE's complicity emerged in the aftermath of the Battle of Jebel Moya in October 2024. The defeated RSF forces left behind arms that can only have been provided by the UAE, including ammunition crates marked United Arab Emirates, GHQ, Armed Forces, Joint Logistics Command, Postbox number 2805, Abu Dhabi, UAE. Notwithstanding its evident knowledge of the ongoing genocide, the UAE continued to supply heavy weaponry through Amjaras airport. This included the provision of sophisticated drones that were increasingly flown out of Amjaras and into the Sudan. Moreover, the UAE has also assisted and aided the RSF in the recruitment of mercenaries to support the attack against El Fasher. On 20 November 2024, a joint military force was engaged in an operation near to where North Darfur borders Libya. After a firefight, the mission was able to collect the passports of certain of the foreign mercenaries. Among them were Colombian nationals whose passports contained entry visas from the UAE from the previous month. As the Wall Street Journal reported, the Colombian mercenaries were hired by an Abu Dhabi-based company called Global Security Services Group, which has presented itself as acting on behalf of the Emirati government. North African officials interviewed by the Wall Street Journal put the number of Colombian mercenaries who have been sent to the Sudan at approximately 160. A detailed Colombian investigation put it at 300. On 7 January 2025, after careful review of the facts and a comprehensive legal analysis, the US Secretary of State correctly determined that a genocide was being committed in the Sudan, stating that the RSF and RSF-aligned militias have continued to direct attacks against civilians. The RSF and allied militias have systematically murdered men and boys, even infants, on an ethnic basis, and deliberately targeted women and girls from certain ethnic groups for rape and other forms of brutal sexual violence. Those same militias have targeted fleeing civilians, murdering innocent people escaping conflict, and prevented remaining civilians from accessing life-saving supplies. Based on this information, I have now concluded that members of the RSF and allied militias have committed genocide in Sudan. On the basis of this determination, the United States sanctioned RSF's commander, General Hamdan, for his role in systematic atrocities. It also sanctioned 7 companies owned by the RSF, as well as 1 individual, for their role in procuring weapons for the militia. They were, all of them, based in the UAE. The UAE Ministry of Justice waited for around 4 months before it responded on 4 April 2025, only after the Sudan had submitted this dispute to the court. And even then, the UAE used notably circumspect language, asserting that none of the 7 entities hold an active business license in the UAE, nor are they currently operating in the UAE. Against this backdrop, as you have seen, the current US Secretary of State felt compelled in January 2025 not only to recognize the existence of the ongoing genocide, but also to call out the UAE for its open support of the entity that is carrying out that genocide. Since that date, the plight of the surviving members of the Masalit group in North and West Darfur has only become more desperate. There are thousands of Masalit in North Darfur, particularly in El Fasher and in Zamzam camp, many of them internally displaced. The RSF is currently mobilizing even greater forces and intensifying its attacks with the aim of breaking the siege of El Fasher, which has been ongoing since May 2024. So important is the taking of El Fasher to the RSF and its sponsor that the UAE is reported in recent months to have intensified its efforts of support in order to ensure that El Fasher falls. If that happens, everything points to a repeat of the atrocities of El Janina. At the same time, the RSF has been attacking gathering sites where there are internally displaced members of the Masalit group, including Zamzam camp. Between 9 and 13 February 2025, following heavy artillery shelling, the RSF launched a ground assault against the camp and raised its main market in arson attacks. The Humanitarian Research Lab of the Yale School of Public Health confirmed on 13 December 2024 the large-scale displacement of an unknown number of civilians from Zamzam IDP camp following repeated heavy artillery bombardment over 12 days by the RSF. It also identified and located 4 heavy artillery pieces, consistent with a type of Chinese-produced 155mm howitzer artillery gun, which it considered were engaged in the bombardment of Zamzam. Yale's Humanitarian Research Lab noted, on the basis of publicly available sources, that the UAE was the only country known to have purchased this type of howitzer. Notably, the Security Council's panel of experts had reported earlier that the increasingly heavy weaponry provided by the UAE included howitzers, and that these had been observed in El Fasher. The assessment of the Sudan is that the howitzers in question, of which there were 11 in total, arrived by UAE aircraft which landed at Amjaras Airport on 1 October 2024 and were transported onwards by truck into Darfur before they were put to use by the RSF. And yet, the nightly weapons and ammunition flights from the UAE into inter alia Amjaras airfield continue to arrive. Sudan's own intelligence assessment in March 2025 is that the flights to Chadian airports transporting military aid to the RSF have continued to the present. To conclude, there can, for present purposes, be no question that there is sufficient evidence that the UAE is not only failing to prevent genocide, but is also complicit in genocide. This will, of course, be the subject of full argument at the merit stage, although direct proof will, to a large extent, continue to rest in the hands of the UAE itself. For present purposes, it is relevant to recall the court's observation in Corfu Channel, that in such a situation, the other state, the victim of the breach of international law, in this case the Sudan, should be allowed a more liberal recourse to inferences of fact and circumstantial evidence. Here, the Sudan has presented a series of facts linked together and leading logically to a single conclusion. Finally, it cannot seriously be argued that the UAE was unaware of the existence of this dispute prior to the filing of the Sudan's application. I can be brief. First, in a letter to the President of the Security Council dated 26 April 2024, the Sudan stated that the support of the United Arab Emirates for the criminal Rapid Support Forces militia, which has waged war against the state and its citizens, makes the United Arab Emirates a partner in all the crimes and atrocities that this militia has committed. The Sudan demanded that the UAE be held responsible for crimes including crimes amounting to genocide. Second, during the Security Council meeting held on 18 June 2024, the Sudan stated that the Security Council must identify by name the state sponsoring that plague which is subjecting the people of the Sudan to gradual genocide. The Sudan concluded, the United Arab Emirates is a country that is sponsoring systematic and ethnically based terrorism in the Sudan. The Rapid Support Forces are supported, sponsored, and incited by the United Arab Emirates to fight in the Sudan and perpetrate crimes and rapes. In the same meeting, the UAE denied all of this as false. Third, during the Security Council meeting held on 11 September 2024, the Sudan stated that the United Arab Emirates fuels the war and supports the militia that has committed the crime of genocide. Fourth, in a press release dated 12 February 2025, the Sudan stated that the RSF, backed by its regional sponsor, is escalating its campaign of genocide against the majority of Darfur's population. The terrorist militia has been waging a brutal ongoing attack on the Zamzam camp for internally displaced persons. It further stated that the RSF targeted internally displaced persons on an ethnic basis. The press release concluded that the militia's regional sponsor bears direct responsibility for ongoing genocide. That, Mr. President, members of the court, concludes my presentation. I ask that you invite Mr. Wordsworth, KC, to the podium to address prima facie jurisdiction.
I thank Professor Gilger for his statement. I now call Mr. Samuel Wordsworth to the podium. Sir.
Mr. President, members of the court, it's a privilege to appear before you and to have been asked by Sudan to address the issue of the court's prima facie jurisdiction. The question is whether Article 9 of the Genocide Convention, which is of course well known to the court and is now on the screen, appears prima facie to afford a basis on which its jurisdiction could be founded. Both Sudan and the UAE are parties to the convention. Sudan acceded on 13th October 2003 without entering any reservation. The UAE acceded on 11th November 2005, subject, as the court will be aware, to a reservation with respect to Article 9. Where an applicant invokes a compromissory clause, such as Article 9, the court must ascertain whether the acts complained of by the applicant are prima facie capable of falling within the provisions of that instrument, and whether, as a consequence, the dispute is one which the court could have jurisdiction ratione materiae to entertain. As to this, the acts of which Sudan complains plainly are capable of falling within the scope of the substantive provisions of the Genocide Convention, and there is a dispute as to the UAE's compliance with the Convention as just outlined by Professor Bjorga. Turning to the reservation, the UAE's instrument of accession to the Genocide Convention states in relevant part that it makes a reservation with respect to Article 9 thereof concerning the submission of disputes arising between the contracting parties relating to the interpretation, application, or fulfillment of this convention to the International Court of Justice at the request of any of the parties to the dispute. Now, where at a provisional measures phase, a respondent invokes a reservation entered in relation to the compromissory clause, two separate questions arise. First, the court must examine the reservation and assess whether it is capable, prima facie, of being correctly interpreted so as not to deprive the court of jurisdiction. That is a question of interpretation. The second question arises if, and only if, the court decides that the reservation can only be interpreted so as to exclude jurisdiction. This second question, of course, goes to validity. Is the reservation capable, prima facie, of being found to be invalid? That is, at the appropriate later stage in the proceedings and after hearing full argument. I deal with these two separate questions in turn. However, as to both, it is useful to recall the observation of Judge Greenwood in his separate opinion in the Georgia and Russia case. Requests for the indication of provisional measures of protection are considered as a matter of urgency, without the opportunity for the consideration of extensive evidence or the detailed analysis of legal issues which can be undertaken in later phases of the proceedings. The jurisdictional threshold which the applicant has to cross is accordingly set quite low, and any ruling, whether as to law or fact, which the court makes at the provisional measures stage of a case is necessarily provisional. Consistent with the quite low threshold that is applied in light of the urgency and the inability to hear full argument, the court has generally refrained from determining disputed questions of interpretation at the provisional measures stage, reserving these to the appropriate later stage. Of particular relevance, so far as concerns reservations, at the provisional measures stage of the nuclear tests case, France argued that the dispute fell within the exclusion from its acceptance of compulsory jurisdiction of disputes concerning activities connected with national defence. New Zealand contested this and maintained that the validity, interpretation and effect in the present situation of the reservation attached to the French declaration are issues which can be the subject of debate, that is, at a later stage, with there being various arguments in favour of the court's jurisdiction. In these circumstances, the court refrained from making any pronouncement on the interpretation or validity of the reservation and concluded that at the present stage of the proceedings, the provisions invoked by the applicant appear prima facie to afford a basis on which the jurisdiction of the court might be founded. And the court then went on to indicate provisional measures. Turning then to the first question, that is the interpretation of the UAE's reservation. This is capable, and a fortiori capable prima facie, of being interpreted so as not to deprive the court of jurisdiction under Article 11. The principles governing the interpretation of reservations are unlikely to be an issue today. In its guide to reservations, the ILC stated that a reservation is to be interpreted in good faith, taking into account the intention of its author as reflected primarily in the text of the reservation, as well as the object and purpose of the treaty and the circumstances in which the reservation was formulated. Of course, any state making a reservation can be expected to have given very careful consideration to the specific formulation of the words it chooses to use. In this respect, unlike in the context of treaty drafting, there is no question of compromise or negotiation with other parties. Focusing then on the text of the UAE reservation, this is notably vague and non-specific. It merely makes a reservation with respect to Article 9, with no wording of any kind specifying the content and nature of that reservation. The rest of the reservation then reflects the wording of Article 9, what it concerns, l'article selon lequel in the French text. Notably, however, what follows omits the key wording on the responsibility of a state for genocide. And as the court recognized in the Bosnian genocide case, the fact that Article 9 confers jurisdictions over disputes, including those relating to the responsibility of a state for genocide, is an unusual feature of the wording of Article 9. Equally to the point, it is precisely the
de la volonté d'offrir aux cinéastes du monde entier et à leurs films une terre d'accueil, un asile, parfois même au sens littéral. Il est né de la volonté de réunir toutes celles et tous ceux qui, au-delà de leurs différences, parlent une seule et même langue, celle du cinéma. Depuis près de 80 ans, le Festival de Cannes dialogue ainsi avec le monde et incarne une France audacieuse, curieuse et ouverte. À une époque où la tension du repli sur soi n'a jamais été aussi grande,